Hello, my name is Brett Bendistis, and this is a short video lecture on legal rules. Once upon a time in my previous life, I was quite the rebel. I used to think that rules were something that were made to be broken. But we all have to grow up sometimes, right? So legal rules are something that are not meant to be broken. They are meant to be meticulously followed at all costs. Rules are not the kind of thing you want to be trifling with. They are actually not only something that you're required to abide by, but they're like easy elements of research. It's a really easy way to sort of vet out a problem that you have that's always a free resource that's usually available. Commonly, your legal rules can be Googled. They're often found at a kind of on the court website. Now, like I said, most jurisdictions have their own websites, and you should be able to get the Maryland rules of civil procedure, the Delaware rules of professional responsibility. They're all available and they're important to note. And what we're going to be covering is what kind of rules are they, how are they applied, and then more aptly, how do you search them? Because I don't want you to be reading 150 pages of rules when there's a really easy way to kind of put that together that should be able to help you out. Now, there's three different types of rules that we're going to be covering: rules of procedure, rules of evidence, and rules of professional responsibility. Now, rules of procedure are how you navigate the legal system. We don't just knock on the door of the legal system like we would knock on the Wizard of Oz. We actually have to follow very particular ways of putting something through, and rules of procedure can be really helpful if you're like a new lawyer or a new paralegal. I found that when my first job was at a law office and I had like no idea what I was doing, right? And I would often get asked, can you file, a motion to extend time? I don't know how to do that. Or a motion to add necessary parties. It's like, who knows, right? So if you go to the rules, very commonly, they will give you a good description of what you need to do, and it will really be able to help you kind of take the steps that you need. It will tell you what has to be in your complaints. When do things have to be filed? What are the deadlines? Deadlines are huge. So this is a big thing if you're in civil law or criminal law, because criminal law has the same thing, although civil procedure has its own sort of scary connotation if you're a first-year law student. Rules of evidence are how does documents, statements, witnesses get presented before trial. Now, just a small matter of background. This is me editorializing. I've always thought that evidence is like really interesting, but it's really dry. It's a really tough thing to sort of analyze. Hearsay exceptions, the best evidence rule sounds cooler than it is, but evidence rules can be really helpful. And not only can it be helpful if you are developing a case, but let's say you're a new lawyer and you're going to trial. If you know what's hearsay and what's not, you can throw a monkey wrench into a lot of not just pro se litigants, but also lawyers who are just sort of taking things for granted. So noting what evidence is allowable is a really important thing to note. It's a good rule to sort of latch onto. The rules of professional responsibility, how judges and attorneys are required to act, are just a really nice thing to note if you're a paralegal so you know what's required of you. You might think, how often do ethical rules come up? Just letting you know they come up all the time. So being able to spot problems, know where they can be resolved, I think can resolve a lot of problems in the future. Here's a small hypothetical, and I just want to go over each individual rule and how they might help. So you have a mom, dad, 2 sons, 3 daughters, right? Family of 5. Mom and dad pass away and leave behind a house to the whole family. So they say, congratulations, here is a financial burden that you'll have to worry about. 1 son and 1 daughter come to your office looking to sell that property. They do not want to co-own it with the other siblings, and they want to be unburdened by property going forward. Property is a pain in the butt, right? Because you got to pay taxes on it, you may have to pay a mortgage on it, you may be getting license and inspection complaints because the grass is too high, right? So they're like, we don't want to deal with this anymore. Another sibling is still living in the house and doesn't want to sell. The reason why there's hypotheticals is because one of them doesn't want to sell, right? And claims that mom said on her deathbed, don't sell the house, right? So she wants to present that as evidence to the court. When we go back to our rules, right? If I am your lawyer, right? I'm like the guy working for you, and I say, let's file this complaint. You might say, I have no idea how to force people to sell a property. Well, luckily, I come to you and say, well, that's called partition. When we look at that problem, right, I think that what we have to do is want to sort of say, well, how do we approach the problem and note where we're going? So the first thing you want to do is find your jurisdiction. So court-specific rules are important to finding what you need. You have to know what court are you supposed to be in. If we're talking about criminal or civil rules, this is clearly civil, right? So that's probably something that we really need to note here. But even in regard to that, we would go, well, what court should we go into? Well, this is a court of equity because we're not suing for money. We're suing to force people to sell the property. So when I say, tell me how to file a partition complaint, you would go to wherever your equity court rules are, look for partition, find the rules from there, and be able to move forward. It makes it a lot easier to be able to kind of pull everything together. We go back to our hypothetical, right? And we go to evidence rules. Where's the evidentiary issue here? Well, if one person wants to bring up a statement of someone who passed away, that's hearsay. Hearsay is anytime someone who is not alive or not present in court wants to bring a statement in, the court takes a kind of a tough eye there. So again, we would go to our evidence rules. We would look up the hearsay sections, read the sections from there, and be able to pull something together. The one thing I really want to note for is I really want to make sure that you are not reading all the rules. There's too many to do. So in there you would go, well, what's a keyword that's associated with the rules I'm looking for? Again, hearsay or partition from the problem from before. They're too long to read, and some of them don't have a table of contents. So the Control F button, it's a find button, where you put one word in and it jumps to where that word is. That is a really easy way to sift through the rules in a very simple way. So if you went to like the Delaware Chancery Court rules and you did Control F, put in the word partition, I believe, I'm doing this off memory, 2 answers will show up. If you jump to the second one, the first one is just regarding how much a partition complaint costs. The second one is all of the elements. It tells you, if you want to file a complaint, all you have to do is parties, the address, how they got it, why they want a partition. If you put those elements in, you're good to go. So if I ask you to do that, you're fine, right? For hearsay, you would go to hearsay, maybe even put in dying declaration. If you've got some, again, background in hearsay, it'll jump you to those rules and you'll be able to move forward, right? Our final rule of rule for here would be professional responsibility. You've got, again, conflict of interests. If you're looking for conflict of interest in the control find thing, you'll be able to know what you're allowed to do, what you're not allowed to do. The problem here is you're representing one son and one daughter. If you really think that you're going to be able to represent 2 siblings here and have them not want to fight and kill each other and you by the time this is done, I think you got to read the rules of professional responsibility a little bit, because one of the problems with property with representing 2 people is the idea that interests will not divulge or dive from each other at some point is an assumption you're better off not making. So that's one of the reasons why we want to note here. The only thing I would add is that citing rules is there's 2 ways to do it, and they're really important actually, because you don't want to just sort of assume that you can do it without looking at the applicable sections. The first thing is that Delaware Citation has like a manual that you can cite, and it's found on Google. If you put in Delaware Citations, they'll have this general form that's really helpful. It'll kind of give you all the obscure rules. Otherwise, Table B2 in your Blue Book has a section of rules that you can actually cite. You just have to change the numbers. So ultimately what you want to do is give that form. Usually like DEL, Superior Court will be Del super period CT period R period, and then the civil or criminal, then the rule. So finding that section is really helpful, because if you're citing, I don't know, the summary judgment rules, that should be Rule 56. That summary, that citation should also be referenced kind of in the applicable rules. So that is legal rules. We have to find them meticulously. We know where to look. We know how to locate them. We know how to cite them. Thank you very much for listening. Again, I have a lot of rules, not a lot of rules, a lot of videos on YouTube if you're interested. You can also locate my podcast. It is The Citizen's Guide to the Supreme Court. And it can be found on iTunes, Stitcher, all that kind of stuff. So thank you guys very much. And I'll see you guys soon.